Any mention?
No mention. Is it 10:30 yet? Madam, ne? Oh, that's a problem. Chalo. Yes. 5 minutes, leave back.
Any mention?
May it please Your Lordship. Your Lordship, I beg to mention item number 25.
Number?
25.
You're there.
Your Lordship, I pray for 2 weeks' time as the conducting counsel has some personal difficulty.
Who's the person? Who's the?
KCH Gautam.
And after puja, yes. The request is little competition. Yes.
Obliged.
Yes.
Yes, Lordship, I beg to mention item number 20 and 21. Lordship, I pray that both this matter may be taken up after 2 weeks.
Has he come back to Shillong?
Yes.
Okay, after vacation, yes.
Highly obliged.
Senior counsel for respondent in 20 and for petitioner in 21 is indisposed, yes.
Highly.
May it please Your Lordship. Lordship, I beg to make a mention of item 24, Your Lordship. As the learned DSGI Dr. N. Muzika is on sanction leave, Your Lordship, I pray this matter be listed after puja vacation, Your Lordship.
But I saw him appearing just now fleetingly on the hybrid mode. Just take a state adjournment.
It's not keeping well, Your Lordship.
Yes, okay. After puja. Yes.
Highly obliged,
Inform the
Your
other
Lordship.
side.
I've informed Your Lordship. May I please Your Lordship. Your Lordship, I beg to mention item 22.
20?
22, Your Lordship. It's a joint request, Your Lordship.
Lordship, this matter is for instruction, Lordship. So I
She's
have
accepting 50,000?
no, Your Lordship.
Then we'll dispose of today only. Puja bonus for you. Dismissal of your case. You want to dismiss?
Lordship, maybe reheard, Lordship.
What to rehear here? Okay, we'll give you that after puja. Then.
Yes.
But then see, whatever rights he might have, we've already heard you.
Lordship.
We have no substance to prove it.
Lordship.
You explain to her. You already explained
yes,
to her.
Yes, Your Lordship. I have explained.
Yes, okay, after puja.
Give the obliged.
Yes, from Tao.
May it please Your Lordship, I beg to mention item 23, Your Lordship. If this matter may kindly be taken up after the puja vacation, Your Lordship.
2 weeks, yes.
Objection, Lordship. Obliged, Lordship. Similar prayer for item 26 as well, Your Lordship.
26, yes. That's it.
Your Lordship. Supplementary list, item number 1.
May it please Your Lordship, before my friend starts, actually my Lord, Counsel Advocate General, Additional Advocate General, and Shula is online, so my Lord, if the matter can be taken up at the end of the board.
May I please Your Lordship? Actually, this matter is the second round of repetition, which the eldest one is before the other bench, and there is other one matter also which is pending concerning the same issue.
Sorry, they can't answer.
No,
this number 1 is what?
This is the second writ petition which we have filed now, and the first one is already disposed, which is placed before the other bench, and the same other matter also is concerning the same issue which is pending before the other bench.
So you want us to go to other bench also?
Yes, Your Honor. Yes, Your Lordship.
Okay. MS S. Marpana and Council Priest submits that as connected matters, which is an issue, as a connected matter on the same issues pending before bench number 3.
Yes, Your Lordship.
Yes, praise that the matter be listed for said bench. Prayers allowed. This says matter before. Justice W. Dunga.
Yes, Your Lordship.
To a bench of Justice W. Dunga, yes.
Item number 2. Item number 2.
My Lord, assembly prayer for item number 2 and 3, the connected matters.
After some time. Yes.
Supply.
4. Item number 4.
Who's for the petitioner? Mr. Jha, is that here? Take after some time. Yes.
Main list, item number 1.
May I please, Your Lordship? Your Lordship, if this matter can be taken after puja, Your Lordship?
We'll finish it off now, yes.
Because as Mr. D is on sanctioned leave, Your Lordship.
You're here? Yes, what do you have to say? You seen the affidavit?
Yeah, I've seen the affidavit.
Yes.
This affidavit, of course, they have filed it, but only my grievance is, Your Lordship. Since they have admitted that this, they have not filed the separate condition.
We will overlook that. Okay. The only thing is that the CM, when this court had disposed of the matter last time, you asked them to go before CM with a condemnation application and with the appeal. Correct?
Lordship.
Now they filed one application, then what the CM did, he didn't decide the appeal. Yes. He took the condemnation matter and allowed the condemnation. But that is discretionary power. So this court would not like to, to interfere with discretion. The merits of the matter will be heard. And even then you'd file an argument also, I think. I've seen the affidavit before CM. So you go there, you argue on merits. What is there? That'll be the outcome. This court is expressing its tentative view. That'll be the only thing. Because it's not the main matter, the merits have not been taken up. It's only on condemnation. The CM said, okay, we condone the deal, we'll hear them. That's all. So I agreeable to that. You go and contest the matter.
Lordship, but only one thing is that the private respondent, they have totally neglected to.
See, that is what, when this court remanded the matter, this court had directed the CM to examine it, and if they had gone asked for condemnation, to examine the condemnation prayer. Now he's condoned it. He has condoned it, and he said, okay, we'll hear the main matter. You had come before this court saying that he's already allowed the case. No, that's not the case. He's already allowed the condemnation, and I'll hear the main matter.
Lordship.
You take part, what is there? But that should be disposed of.
Yes, Lordship, you can dispose it.
Yes, you have anything to say?
No, Your Lordship, because I don't have instruction right now, Your Lordship.
You have the file with you?
Yes, Your Lordship.
Then very good. You have the file with you also?
Yes,
Then you have objections, hence the case been disposed in your favor.
Your Lordship.
What to do?
They're taking time, so maybe
It's a very absurd situation here. So as prayed by the council for a spotless matter after 1 week.
Lordship.
He's agreed.
Item number 2.
Much blessed you, sir.
May it please Your Lordship, Your Lordship will be filing the affidavit bringing on record the order sheet in the course of the day, Your Lordship.
Last was on the 5th. Ms. CB Savian submits that the order sheet will be filed in the course of the day, just after puja vacations.
Obliged. Item number 3.
Look, you matter. Oh, what is this here?
May it please, Your Lordship.
Yes. What order is seeking modification? What matter is this?
It was a stay order, my lord. It was passed on the 12th.
On the?
On the 12th this month. It was a stay order.
Where's the order? You annexed it to your case?
I had annexed. Oh no, I had not annexed.
Why?
My lord. Because I referred to the previous order as in the SA.
You have to be part of the petition only.
Sorry.
If you're seeking, you correct it, you file it.
My lord, obliged.
Mr. C.H. Molong, please let me out to file a copy of the...
Lordship, if I can jump
Yes.
in, this particular miscase is not in the list today. It's not listed today.
What's on the list today? What's it for today?
The main second appeal, my lord.
My lord may be permitted to file a fresh
Yes, you file it.
application for.
Yes, Mr. Sage Molong, Leonard County, appearing for the respondents.
Respondent.
The respondents submits that a case has been filed. He prays they will have to
File a fresh application for
file a fresh application
vacating the stay
vacating of the stay order dated
12th this month.
Is it until further orders or until the next date?
Until today, my lord.
Yes, the interim order passed and will continue the next day.
And also, my lord, the lower court records have been received. I may be permitted to prepare a paper.
Why lower court records?
Because it's the second appeal, my lord. So,
Might not be necessary.
let it come,
second appeal.
let it come first. Has it been admitted?
it has been.
Has been admitted?
It has
no,
been
for
admitted.
hearing.
No, my lord.
No, if I can point
Second
out,
appeal, how admitted? Substantial questions of law has been framed.
it's been framed.
No.
Your Lordship, you may kindly look at the last order, 12th October. It has been admitted.
Strange.
It has been admitted, my lord. Substantial questions.
How?
Lordship, may look at the third page of this order, my lord.
Long order.
It's a long order, my lord.
They had appeared that time. He had appeared so long.
They were under
We had appeared, however, I was not present, my colleague was present. And he has reflected in the order, but I was not present, my lord.
It was admitted. Usually, I mean, this bench goes through the process of, having admission hearing, because if it's not, if there are no substantial questions of law involved, then we'll cut it off at the admission stage only. Yes.
Lordship. So since it's been
It's admitted, let this come next date.
Very well.
Yes, we'll pass whatever order is necessary.
Obliged.
Contempt. No.
It's a review application, my lord. We have received the affidavit filed by the private respondent, my lord. Mr. Preem, this matter can be fixed for hearing after pujas, my lord.
Has the review been admitted?
Review has been admitted, my lord. In fact,
You sought time to take instructions for what?
correct, my lord.
Yes,
Instructions, my lord, in view of what they have stated in the affidavit, there was certain instruction required, my lord. We have obtained that, my lord. We can have it.
What are the instructions? What are the instructions required?
My lord, actually, what they are claiming is what I am claiming is a different proportion
What
of
they were
land.
saying, my lord,
So that
here
is purely
is
a claim and counter
they
claim.
sought to demarcate my land as well without me being as a party, my lord. So we had come as a review. Your lordship had state that order. Now they have come up with the plea that my land and their land is entirely different.
Yes, my lord.
So in that,
Listed
These
after
land
the
is
applications for
adversary to
admission
mine.
hearing.
Yes,
We'll
ma'am.
dispose it of, yes.
oblige. Hello, oblige.
So and so date for admission hearing.
Item number 5.
Your Lordship, I pray that the matter may come up after Puja Holiday. Mr. Upadhyay is now in courtroom number 3 having 2 legal aid matters. And moreover, we have just received the file of the lower court, trial court case just day before yesterday.
No, last time you said you could not conduct the case as earlier counsel not consented to let go of the brief.
Yes, Your Honor,
So
but
what's happened
he
now?
has handed us the file of the trial court just day before yesterday.
Sorry, my lord. They've been taking the lower court for a ride for the last 4 years. They're attempting the same thing with this honorable court now. They entered appearance in August. Now they say 2 days back they got the file, my lord. Sometimes they say senior counsel is appearing. Next day they say he will not be appearing.
We received the file of the
sometimes they don't appear without
CRP,
any reason.
But to prepare this, we need the records of
It's a
the
very,
trial court
very
also,
small
the
matter, very,
title
very
suit
small
and
issue, my
everything.
lord. I'm not sure
So without that, we cannot.
why are they avoiding the matter. It's a very small, limited issue, my lord. In fact, Lordship's last order is very clear, my lord.
So last chance may be given, Your Lordship.
Okay, I was expressed a difficulty to conduct the case today. I expressed a personal difficulty to conduct the case today. List the matter on reopening for admission hearing.
Lordship, my objections may kindly be.
Yes, the Mr. Ejendal has, Ms. Sindram has expressed her personal difficulty to conduct the matter today, which is strongly objected to by Mr. S. Ejendal, the counsel petitioner. However, in interest of justice, this is a matter after future vacations for admission hearing. Also, Mr.
Item number 6. Item number 6.
May it please, Lordship.
This contempt
Yes, Lordship. This is a contempt case, Lordship.
What happened? Why not comply?
Lordship, looking at the documents, I don't think this is a contempt case, and moreover, I don't think we will need to file an affidavit. Lordship, I'll place us.
Are they privy to these documents also?
What document is that? What document is it?
I'll supply you. Lordship, here the petitioner says that the respondent have deliberately and willfully disobeyed this honorable court order dated June 13 of 2022. And seeing the records, Your Lordship, that order was passed directing us to implement the communication letter dated, Your Lordship, 4th March of 2022. Now, Lordship, if I take Lordship to the acknowledgement receipt which I have placed before this honorable court right now, Lordship, we have been directed to pay the amount of rupees 1,96,000.
Yes.
And which we have complied, Lordship. Yes. And the same has been acknowledged by the petitioner on 16 August 2022, Lordship.
What you paid to the petitioner's lawyer?
No, Lordship, we paid to the Maltisha, Lordship.
Oh, see, this one amount received on behalf
of the
petitioner by counsel Mr. S.E. Sheikh.
Yes, Lordship.
I don't question that, my lord.
Then?
Yes. Therefore, Your Lordship, we have complied with this order as well.
What is your complaint regarding violation?
My contention is that, my lord, the pending salary, which was withheld after her termination of service, was not paid to her. Communication after excommunication from the village and termination of service was not paid to her.
What about these documents? What is officiating document of some other person?
This, Lordship, we revoke as per the direction of this honorable court. We have
Mr. Yobin, I think for the court to take proper cognizance of these papers you have furnished, you file an affidavit. Then we'll dispose of next date.
Yes, Lordship.
Right. Then give them a chance to rebut if they feel that it's not correct. Take it
yes,
back.
Lordship.
Mr. Yobin has produced some documents today to show that the amounts due to the petition has been paid and that there has been no violation of the order dated.
Order dated 13th June 2020.
13/6/2023. However, NEPA is directed to file the same by affidavit. However, he decided to bring the same on record by affidavit. List on so and so.
7.
Lordship, we have filed our show cause, and we have also alleged that in fact criminal contempt proceeding should be drawn against the Ramashnong of Lankra and including the chairman. And
why criminal contempt?
And I have supplied a copy of the show cause to my colleague.
It is the contemptor who has disobeyed the order.
You have to go to if we have really disobeyed or whether they have disobeyed.
You have not made any complaint, so anyway,
My lord, I would like to file one small affidavit, my lord. I'll bring it on record.
Yes, affidavit on behalf of the contemptor, on the alleged contemptor, has been filed. Stop Mr. Ensign Funds allowed 2 weeks time to file rejoinder to the same. Otherwise, he's volunteered to go to jail on behalf of the.
Whether I should go to jail or whether Ramashnong Lankra will go to jail. That's a question.
No, you're volunteered to go to jail on behalf of your client.
No, if this court find that I have committed contempt, I'll go to jail. Or if they have committed contempt, then they will go to jail. Much obliged.
May I please, Your Lordship? Your Lordship, in this matter, we will file the rejoinder affidavit in the course of the day, Your Lordship.
She won't allow you.
I have no objection.
No objection? Okay. Because what is the last order?
Yes, Your Lordship.
Then?
In the course of the day, Your Lordship.
MS and Raji submits that I will find the course of the day. Well, this is matter after so and so. After vacation.
Much obliged, Your Lordship.
Item number 9.
Please, Your Lordship, praying for some more time to file a rejoinder.
How many times you've asked, Mr. Jinder?
This is the 3rd time, Your Lordship.
I'm preparing for respondent number 4, Lord.
And Mr. Kinta for 1 and 2. What about 3? 3 is whom?
Mr. R.K. Simram.
Please, aim of Riau.
Yes, Your Lordship.
Have you filed affidavit?
They have filed the affidavit, Your Lordship. They have filed the affidavit, Your Lordship.
Number 3 is filed. I filed rejoinder to whose affidavit? Number 4 or whom? Whose affidavit filing rejoinder to?
To 1 and 2, Your Lordship.
1 and 2?
Yes, Your Lordship.
You didn't file affidavit? Then what
3 and 4, Your
file?
Lordship. My apologies. 3 and 4, Your Lordship.
Okay, Mr. S.G. Dingdo appears for allowed 2 weeks time final opportunity to file rejoinder to the affidavit filed by sponsors 3 and 4. Yes,
10.
Lordship, I pray for 3 weeks' time to file rejoinder. We have received the affidavit.
Your Lordship, we're filed.
MS Islam prays for allowed 3 weeks time to file rejoinder to the affidavit filed by the respondents. Yes, so.
11.
May it please the Lordship. We've received instructions, the Lordship. I may be given short accommodation, the Lordship.
What about 6 to 8?
2 to 5. This is regarding the holding of annual general meetings and.
Or school?
No, not the school.
Registered
It's a society. It's a society where the petitioners have challenged the new members of the society.
Has 6 and 8 been served?
No, Your Lordship.
Has not been served?
Your Lordship, pardon?
6 and 8?
No,
One and
Your
6 to 8?
No, Your Lordship.
6
They
and
have
8
not
or
filed.
6?
In fact, none of the respondents have filed the counter. I mean,
No. Have they appeared?
I think they had appeared, no, in the
6 to
last
8?
date. Yes, they have appeared, Your Lordship.
Who was appearing to behalf?
I think Nongbri.
No.
We have served the copy, Your Lordship.
Or PS Nongbri?
PS Nongbri, yes.
How many dates he hasn't appeared? Okay, 25 days.
We have been seeking time more than 3 times, Your Lordship.
That is correct, Your Lordship, but we did
MSD
not.
Yangi submits that as she has just received the instructions, she may be allowed some more time to file affidavits. Prayers allowed. So it's noted that there has been no appearance made on behalf of the respondents 6 and 8.
Your Lordship, I'm appearing on behalf of respondents 6 to 8.
Okay, then why don't you come forward? What is your name?
M. Lightman.
You filed your affidavit?
We are yet to file our counter affidavit.
Yes, okay. Swapna? Swagato? Stop. M. Lajman appearing for 6 and 8 also has a similar prayer. Only 3 weeks time is granted for affidavit, this thereafter and so on.
12.
Lordship, respondent number 5 has filed affidavit. Lordship may give me some time to give my short reply.
Yes, for 5.
Number 5 is filed.
Mr. H.H. Social Councils prays I will allow some time to file the joinder with the affidavit filed by the respondent number 5. Prayer allowed. Yes, after 3 weeks. Yes.
13.
Your Lordship, we have just received the affidavit filed by the states.
Your Lordship, we have not filed. I'll be filing in the course of the day. I've just served a copy to them, Your Lordship.
This one we also have filed, Your Lordship.
6.
I have filed on.
What do you want to file the joinder?
Yes, Your Lordship.
MS Ailingwa submits that the affidavits on behalf of the respondents 1, 2, 3 and 5 will be filed in the course of the day. So next one, MS Iwi Pasa submits that the affidavit on behalf of you're paying for 4, right?
Yes, Lordship.
On behalf of 4 has already been filed. You also filed?
Yes, Your Lordship.
Yes, MS Tomni, MS Ibi Pasa for number 4 and MS Ngurung for number 4 and for number 6. Submit that affidavits have already been filed. This is a matter after 3 weeks for rejoinders, if any. Yes.
Obliged, Lordship.
14.
Please, Your Lordship. 2 weeks time is granted for filing rejoinder affidavit against the affidavit filed by respondent 1, 2 and 3.
Lordship, here also I pray some more time to
4.
file my...
You're for 4?
Yes, Lordship, to file my affidavit, Lordship.
You're Mr.
S. Islam.
Mr. S. Islam for petitioner. Please allow 2 weeks time to file the rejoinder to the affidavit filed by the respondents 1, 2, 3. Mr. S. Sheikh, number 4. Please allow similar time to file affidavit. Prayers allowed. List after 2 weeks. Yes.
Hello.
15.
My lord, this is regarding service benefit, my lord, retirement benefit. Now, my lord, on the last occasion, my lord has gone through all the documents which was placed before the court. However, they have filed the affidavit, they have not enclosed even one single document, my lord. Now, how the court will decide? And this amounts to suppression, my lord.
What document they showed to the court last time?
My lord, they have placed it before the court.
Was just an excuse which just shows that she was working as a ad hoc basis.
These documents relating to this particular case should be enclosed, my lord.
Why not enclose the documents?
Lordship, that case,
they have suppressed the facts.
What do you mean that case? You're constantly preparing, defending the state.
Lordship, the case out here is Lordship is the prayer out here is for releasing of the sanction of the pension amounts, Lordship. I'm just stating in the affidavit that she's not she's not regularized, Lordship. That's why
Last occasion, my lord, they said inadvertently her name was not forwarded for regularization. And the documents were there, it was placed before the court. They have not enclosed even one single document.
That's why, Lordship, in my affidavit.
Who prepared it? You prepared it?
Lordship, that's why in my
I mean the statement that she was erroneously left out.
No, Lordship, but in paragraph 3 I said that the department has, Lordship, I've stated the department is taking up the matter and is forwarded to personal
department. If a person has served, given the best years of her life to service, and if on a small technical ground she's not being given pension, he thinks the affidavit will suffice.
Lordship. Then Lordship,
Mr. H. Karanlang, please will have to withdraw affidavit file on behalf of the state and to file a fresh one with complete details. Prayers allowed just after 3 weeks. You do it, otherwise it's a pension matter. You can't deprive a person. After you serve, you say that not regularized. And I remember now, on earlier occasion, you said that because her name somehow had been left out.
Lordship.
Who's the officer who sold the affidavit?
Lordship is a joint secretary.
Of what department?
Health department, Lordship. Health welfare department.
He approves the affidavit, says it's alright.
Lordship, because
as I make him appear personally. The pension case is court take very seriously, and you can't just sidestep it like that.
Lordship.
Yes. You withdraw the affidavit.
Lordship.
Wait, Your Lordship. My Lord, this is that Weybridge matter, my Lord. The license was granted for up to 25. Then it was suddenly cut short, my Lord, without citing any reason, without any.
What's it for? Today, what's it for?
Today, my Lord, on last occasion, Lordship posted it today, and interim order has been extended till today, Your Lordships.
You are happily running the check gate for now.
My Lord, but the way they have done, Lordship heard the matter at length, and Lordship has noticed, my Lord, the kind of discrepancies.
What is the
The kind of discrepancies, my Lord, they have done in this matter. Lordship has heard the matter, Your Lordship.
There is no lease agreement approved by the state government. That's very clear. And
oh yes, I remember. That is that permission and lease of Weybridge.
And there was a first round of litigation where they filed an affidavit and they said we are doing it. Lordship has taken note of that and disposed of the matter.
Misinterpreted and to hold that the Lordship has permitted the petitioner to have the another round of or another 3 years.
Oh yes.
His lease was for 3 years only, my Lord, 2017 to 20. And then
ready to matter today? Lordship will take it up today.
Why not?
Start, yes. Or if I can make it.
Yes, you ready with the matter today, Mr.
I'm ready. I'm already.
Lordship, if we can make a prayer, my Lord, immediately after vacation, because court is reopening on 30th, Your Lordship. Lordship, you can take up on 30th or 31st, Your Lordship. Today normally becomes the last day before vacation, my Lord. We have some matters spread here and there, Your Lordship.
I'm ready.
In the puja spirit, Mr. Sen.
Not that, my lord. Last day what happened? Your lordship is fully aware, my lord. We have some matters spread out here, there, my lord, in the civil court here, there. That's the only thing, your lordship. Immediately after, my lord. I will not seek any adjournment. Immediately after, my lord. 30, 31st, any day.
Mr. S. Sen, Contempt petitioner, prays that some accommodation be given, since it being the last day before vacations, that the matter be taken immediately after puja, after the certification. Yes. The same not objected to by Learned Advocate General. This is matter after puja vacation. Interim order passed shall continue to the next date.
Interim order continues, my lordship. Obliged.
17.
Yes, lordship. This is with regards to the payment of gratuity, lordship. The last occasion, Mr. Karwalang appeared, and then for two reasons they have not appeared.
Mr. Sen, you are here on the matter.
Lordship, we have instructions. We may be granted about 5 months' time on it.
5 months' time. This is an MPC matter.
Lordship.
Yes. Similar order we passed.
Similar order for item number 18 as well on it.
5 months.
18, my learned friend is appearing.
This is 17, 18. 5 months, yes.
Highly pledged.
MPC?
Supplementary list, item number 5.
Yes.
Looks, these are those electricity matters where we had raised the preliminary issue of maintainability.
But we adjourned it because we adjourned it because Mr. Jindal was had some submission to make. What submissions does he have to make?
Limited submissions, my lord, on the
Last
issue
time
of...
we adjourned it on your accord.
That was
And he
quite some time
wanted to
back.
file some reply also, my lord. He wanted to.
You filed a reply?
No, I haven't filed a reply.
Let's see if we really took time to file reply or not.
No, I didn't take.
If you had, then we will extract some cost.
I'm sure of that. I had taken 1 week's time. I had taken indulgence of a week just to get some instructions, which I got.
Oh, that's correct.
At least
26/9, my lord, is on.
Yes, so he's right. He's right. He don't want to. He just he's very particular. That's why.
about the instruction.
Yes. You ready with the matter today?
I'm ready, my lord. The issue is very short one. If I place my case, my lord.
Yes.
Because I am challenging the issue of maintainability, so your lordships would have to hear us first on maintainability.
Mr. Paul has already argued.
No, I have not argued. Your lordships had, we had started the arguments. If I can just finish, we had started, Millets, and then your lordships were of the view that your lordships wanted to see the video recording which was produced by the petitioners. That your lordships have perused, Millets. But the issue of maintainability very much remains because
they'll have no bearing because they'll have no bearing. I'm not taking your consideration. Just that, just for.
Because here the issue is very simple, Millets, that in the very same matter.
Now your case is that it stems from the same special
stems
tariff
from the same matter, Millets.
that it had come for this court.
Lordships.
Then the division bench. Then it gone back.
I'll very quickly put it, Millets. We had originally approached your lordships. Your lordships had allowed the writ petition. After your lordships allowed the writ petition, my lords, the MACL went and appealed before the division bench. Division bench took a view, Millets, that the writ court was not the competent forum and we should go back to the MACRC. We went to the MACRC, my lords, certain orders were passed. That order came to be challenged, my lords. First round, it came to be challenged before your lordships in single bench. Second round, it came to be challenged before the division bench. Division bench took a view, my lords, that writ petition is not maintainable. They have the remedy of appeal. They have to go and file an appeal. The order of the division bench was carried an appeal before the Supreme Court. Supreme Court reiterated that position that writ petition is not the remedy. They have to go and file an appeal. As of today, and so far as my instructions are, my lords, they have not filed an appeal. Thereafter, my lords, the writ petition originally...
Again, which order is this order here?
I'm sorry, my lords?
Against the order here?
No, my lords.
There's another order.
The earlier order, the 512 order.
Okay.
After we filed the MACRC case before the commission, my lords, the commission passed an interim order on 5/12/2022. That was the order which was brought in appeal before the division bench. Division bench did not interfere, said you go and file an appeal. That order challenged in April before Supreme Court. Supreme Court says go and file an appeal. In the meantime, my lords, the other matter, the original matter that came before your lordships taking the same view of the division bench, held that writ petition is not the remedy, you go and file an appeal. Matter ends over there. Thereafter, my lords, what they did is, in spite of the interim orders passed by the commission, under which, my lords, they were required to charge us tariff under the special category, they raised bills under the normal tariff, my lords. So another miscellaneous application was filed for reiteration of the earlier order. The earlier order was reiterated. Proceedings on one of the orders from there, they have taken and brought it in challenge before your lordships. That is the sum and substance of this matter. So in the garb of this writ petition, my lords, may I finish?
Completely incorrect, my lord.
Very good.
Let him finish.
I may be absolutely wrong, my lords. I may be absolutely wrong. The learned Advocate General will clarify that. But let me finish. Now the question arises, my lords, that once your lordships have taken a view that a writ petition is not the remedy, the matter has attained finality after they have gone before the Honorable Supreme Court. Whether they can come back before this Honorable Court and file a writ petition challenging this. That's my first objection. Now the second thing is, my lords, they have invoked the jurisdiction of this Honorable Court both under Article 226 and 227.
But they have to take a choice. That court has expressed last time.
That, my lords, even after it has fallen from this Honorable Court, my lords, no amendment to the writ petition has been made. It continues to be a writ petition both under Article 226, 227. That, in my humble submission, my lords, is not maintainable.
Not maintainable. Both of them not maintainable.
And the third and the most important thing is, my lords, the issue which they are trying to express before this Honorable Court is that there was this member judicial earlier who had retired and thereafter he was working as a consultant, and there is no member judicial before the commission. That matter has become an issue of academic debate because there has been a fresh appointment of a judicial member. Now, the only reason, my lords, why they are interested in keeping these proceedings pending before your lordships and some interim order operating is because there are contempts filed against them for continuing to raise bills under the normal tariff in spite of specific orders by the commission.
Contempt is pending way.
Before the commission, my lords. We have filed for contempt because this is blatant violation. Since 5/12/2022, my lords, there are orders that you will raise the bills as per the special tariff till the matter is decided. They continue to raise bills under the normal tariff. And when we do not pay it, my lords, they force with a disconnection. So we are forced to pay the differential amount, which we are praying under protest. Now, in this backdrop, my lords, I humbly pray with your lordships whether your lordships will first consider whether the writ jurisdiction of this Honorable Court under Article 226 can be maintainable or not. Now, what I have submitted, my lords, I will very quickly take your lordships to the annexures so that when my learned friend is submitting, my lords, that it is not the same case, your lordships will know for yourself.
My case, my lord.
But I am on maintainability.
No, Mr. Advocate General, wait. The only thing is that yes, on maintainability. Now, firstly, I correct. If I remember correctly, like
the first judgment was delivered by your lordships.
No, we expressed that. No, we had expressed that you can't come under 226, 227. You have to take a call on this. Whether you are coming for a score on 227 or you come to 226. And the remedies will be different.
First answer, my lord.
If you come to supervisory jurisdiction, then it's 227. You cut out 226 then.
Your lordship has
Then the scope of 227 is even more restricted.
Yes, so then we'll look at 227. What's wrong with procedure?
This is who was settled. Now, second issue, my lord, what my friend is saying, that look, this honorable court has already settled the issue and therefore this honorable in the previous round of litigation. That is the submission, my lord. If I understand that previous round of litigation, this issue
my lords, before my learned friend starts. Mr. Advocate General, would you kindly give me 2 minutes? Just one.
Okay, wait. Listen.
Just one clarification.
Listen. Mr. Amit Kumar. Wait. Please. Let him complete submission. What do you want to show?
Yes, sir.
Well, I'll first draw your lordships to page 260 in Annexure 7.
216.
260.
Annexure
7. Your lordships have it.
Yes.
This is at page 261, your lordships will see this is the judgment delivered by your lordships.
Yes.
My lords, on 1/7/2022. This is the genesis of this entire thing, my lords.
It has no connection whatsoever.
Okay, wait.
You'll have your turn, yes.
Well,
then, and if it has no connection, my lords, I don't understand why they have annexed it. Anyway, be that as it may. Your lordships, thereafter,
Mr. Aman Kumar, you'll have your turn, please. You'll have your turn, please. Otherwise, you'll just digress something else, please. You'll have your turn, please. Yes. You're both senior counsels.
My lords, at page 278,
Yes.
At page 278,
contain yourself.
Annexure 8 is the appeal filed by the MACL, my lords, MEPDCL.
Okay.
This is the judgment on order dated 5/9/2022. And the operative portion of the judgment, my lords, if I may take your lordships, at page 287, my lords.
Yes.
Paragraph 17 onwards, my lords, I'll very quickly read.
Yes.
There's no basis to the writ petition, and the writ petitioner appears to have failed to meet a concentration precedent as indicated in its governing agreement to be entitled to the beneficial tariff. Since the writ petitioners raised disputes pertaining to the failure to meet the load factor, the writ petitioner had to carry the grievance to the State Electricity Regulatory Commission and not invite the writ court to go into disputed facts. For the aforesaid reasons aforesaid, the judgment dated so-and-so is set aside. Writ petition is dismissed with liberty to the parties to approach the State Electricity Regulatory Commission in accordance with law. On the basis of this, my lords, we then filed at Annexure 9, my lords, at page 288, we filed the MSCRC case before the Commission.
Yes.
And, my lords, at page 303.
Yes. That's annexure.
My lords, this is annexure 11.
Just before the yes.
This is before the MSCRC, my lords.
Yes.
At page 305, your lordships will find the date of the order 5/12/2022. And if your lordships kindly have the operative part at page 311. Your lordships have it, my lords. Paragraph above para 22, my lords, 2 paragraphs above 22. Accordingly, considering all the facts and circumstances of the case as stated in the foregoing, we find and hold that it would be just and proper that the ex parte ad interim order dated 30/10/2022 passed by the Commission be made absolute till disposal of the main petition so as to avoid multiplicity of proceedings and for the end of justice. Hence, it is hereby ordered that the principal respondent, Meghalaya Power Distribution Corporation Limited, is hereby restrained from giving effect to the termination notice and subsequent notices issued by the principal respondent as stated above, and from disconnection supply of electricity to the applicant's petitioner's company till disposal of the main petition. However, it is categorically made clear that the principal respondent number 2 may recover due for energy consumed by the applicant's petitioners based on the special tariff rate approved by this commission, as also incorporated in the MOU and tariff for financial years 22-23, and the applicant petitioners shall pay the bill within 30 days from the date of this order if already not paid. The principal respondent may take steps for realization of the bill as stated above. The arrear, if any, payable by the petitioners, applicant's petitioners shall be subject to the outcome of the main petition. So this is the order dated 5/12/2022, my lords.
Okay. Simply mark 22-23, my lord. Kindly mark 22-23.
No, it's okay. Wait, you'll have your turn. Don't worry.
Yes.
Yes.
That order, my lords, came to be challenged before this honorable court, my lords, at Annexure 12, page 316.
This is 316 is division bench.
Division bench, my lords. Because they took liberty from this honorable court, my lords, that this matter be taken on the before the division bench. And the division bench, my lords, passes an order at page 317.
Para 3.
My lords, para 3, para 6 is the operative portion, my lords, if your lordships kindly see.
Yes.
It is possible that in view of the order dated 5th September 2022 passed by this court, there may not be any merit in the petition filed by the private respondent before the commission. However, such an argument may be carried in appeal, and merely because the petition has been entertained and an interim order has been passed does not amount to the commission having acted without jurisdiction of the kind that would excite the writ court to receive the petition without an alternative remedy being exhausted.
Okay.
The merits of the matter have not been gone into, my lords. they were basically directed to go and file an appeal. Now, thereafter, my lords, against the ad interim order, they had already approached this Honourable Court. A matter was pending at Annexure 13. Your Lordships have passed an order on 31/1/2023.
Yeah.
At page 320, your Lordships will kindly see.
Yes.
In view of the said decision of the division bench, this matter has been rendered infructuous and the same is accordingly disposed of. So your Lordships also close that matter, my lords.
Okay. What happened thereafter?
My lords, if your Lordships come to page 321, Annexure 14. My lords, they approach against the judgment and order passed by the division bench, my lords. They go before the Honourable Supreme Court. Supreme Court takes this view, my lords. Mr. So-and-so, learned senior counsel for the petitioners, after some deliberations, prays for liberty to withdraw the special leave petition so that the alternative remedy as suggested in the impugned judgment can be availed by the petitioners. Nothing, noting the above, the special leave petition is dismissed as withdrawn, reserving liberty as aforesaid.
Now they have not.
Till today, my lords, no appeal has been.
That 512 orders have been assailed.
As far as my instructions are concerned,
wait, Mr. Amar Kumar, I'll give you
as far as my instructions are concerned,
I would allow support interrupt that time.
As far as my instructions are concerned, my lords, no appeal has been filed. We have not been served with any notice.
Okay.
Now, thereafter, my lords, what happens is, now I'll take your Lordships to the impugned order which is there before your Lordships, my lords. Your Lordships would find that at page 40.
40?
Yes, my lords. For the
That's
convenience,
11 July.
Balance. For the convenience of this Honourable Court, I may be just permitted to very quickly just run through this entire order.
Entire order?
Balance, because this will clarify what is the dispute before the Commission. Or if your Lordships permit, I'll just go through I'll very quickly read it, my lords, so it will be very clear what is the dispute.
Is it?
From page 40, my lords.
Yeah.
It is about 7 pages, my lords. We'll skip the relevant portions because individual writ petitions have been concerned, my lords, so I'll skip that part. The above batches of interlocutory applications are filed by the members of BIA, in short, and against the same respondents. The facts and issues involved and the reliefs prayed are also the same. Thus, I propose to dispose of the above batches of interlocutory applications by a common order. Before proceeding with the present interlocutory applications and the prayer thereof, let me briefly state the backdrop and circumstances leading to the present applications of the petitioners. The applicants' petitioners, which is part of a collective body that goes by the name of BIA, filed petition individually inter alia stating that the MOU for special tariff was entered between performer respondent BIA and the present applicants are constituent members, and the principal respondent number 2 for sale of power to the members of BIA at a special tariff, and the same was approved by MSARC by order dated so and so. Consequently, and in pursuance of the MOU, and agreements were also entered into between the principal respondent number 2 and the present individual applicants petitioners, wherein terms of the MOU were referred and incorporated by the agreement dated so and so. That the petitioners applicants came to know of the termination notice of the MOU from the performer respondent by so and so, issued by principal respondent number 2 on the ground that the petitioners applicants failed to maintain 68% minimum average load factor, which is one of the conditions incorporated in the MOU. Subsequently, principal respondent number 2 issued termination notice dated so and so to the petitioners applicants for discontinuation of the special tariff, and if the petitioners applicants desire to avail of power from the principal respondent, the same may be considered as per the normal regular tariff applicable to IHT and IEHT consumers as provided under the MSARC for financial year 2021-22 after execution of fresh agreement. Thereafter, the applicants petitioners received notice letter dated so and so, respectively issued by the principal respondent number 2 to make payment of the outstanding amount arrear within 15 days from date of issuance of the order notice, and if there is no response forthcoming from the respondents petitioners, all legal rights shall be explored, including but not limiting to legal proceeding necessary in accordance with law. Thereafter, on 11/10/22, the applicants petitioners were informed by the principal respondent that the electricity supply will be disconnected if area due is not cleared. With these facts, it may be recalled that the petitioners preferred WPC number so-and-so, that is the original writ petition, before the Honourable High Court of Meghalaya, challenging the letter of termination, and on hearing by order dated 1/7/2022, the Honourable High Court was pleased to allow the petition filed by the petitioners. The principal respondent preferred writ appeal number so-and-so before the division bench of the Honourable High Court of Meghalaya against the said order dated 1/7/2022 passed by the Honourable High Court in WPC number so-and-so of 2022. The Division Bench of the High Court of Meghalaya, by order dated 5/9/2022, disposed of the said appeal, thereby set aside the order dated 1/7/2022, passed in so-and-so, with an observation that the petitioner had to carry the grievance to MSCRC and not to the writ court to go into disputed facts and give liberty to the parties to approach the State Electricity Regulatory Commission. Hence, the petitioners, applicants filed petitions by so-and-so, hereinafter referred to as the main case, challenging the termination order of MOU issued by the principal respondent number 2, along with a prayer for giving direction to the principal respondent to withdraw, recall and or otherwise forbear from giving effect to the termination notice dated so-and-so and subsequent notice dated 17/1/2022. Quash and set aside the notices, allow the petitioner to pay electricity bills as per the special tariff, interim relief, restrain from disconnecting supply. Along with the petitions, the applicant's petitioners also filed interlocutory applications praying for grant of ex parte ad interim order, as they had apprehended disconnection of power supply and they were being informed on 11/10/2022 by the principal respondent that the electricity supply will be disconnected if area due is not clear, and also pray to stay the operation of the notice dated so-and-so. On hearing the learned counsel for the applicant's petitioners on examining the applications, the petitioners, including the materials on record, ex parte interim order was issued on so-and-so, thereby restraining the principal respondent number so-and-so from giving effect to its notice dated so-and-so, and from disconnecting or supply to the applicant's petitioner's company, and to maintain status quo ante, and issued notice to the principal respondent to show cause as to why ex parte order should not be made absolute. On issuing notice summons, the principal respondent number 2 appeared and filed written objection against the applicant's prayer in IA number so-and-so, whereby the principal respondent number 2 pray for vacation of the ex parte ad interim order dated so-and-so passed by this commission. On the ground, inter alia, the relief extended to the applicant's petitioners is without any justification and allows the applicant's petitioners to benefit from its own wrong, and there is no legal right of the applicant petitioners to claim a right of purchase electricity tariff of its own choice. The petitioner respondent in its written objection also prays to dismiss the main petition filed by the petitioners. However, no separate written statement is filed by the principal respondent against the main petition of the petitioners. The applicant petitioners filed subsequent pleading denying the entire averment of the principal respondent objection so-and-so. The principal respondent main contention is the petitioner's applicants failed to maintain 68% load factor, and as such, the termination of the MOU in terms of clause 17 of the MOU was valid. Thus, the principal respondent does not dispute its termination notice of the MOU and issued by the subsequent letters notices. Further, the principal respondent submits that there are 3 cardinal principles of prima facie case malus. I'll skip that part. Accordingly, the principal respondent prays to vacate the interim order dated so-and-so and also dismiss the main case filed by the petitioner applicants. Hearing of the parties was conducted and recorded through video conferencing on 22/11/2022, and an order was passed on 5/12/2022. The prima facie findings of the commission in the hearing and passing of the order dated 5/12/2022 was based on the finding that, I'll skip this A, B, C, D, E. I'll take your lordships. Reference was made to so-and-so. You can skip, and your lordships can come to page 46, after I.
What is the installation of ABT?
This is what is the finding of that order of 5/12/2022. If your lordships please, I can read it.
No, it's okay.
I have already taken your lordships to 5/12, so I did not bother your lordships. Does this commission, paragraph 3, at page 46. Thus, this commission found the above foregoing issues requiring adjudication. Accordingly, the commission held that prima facie case is made out to go into trial in favor of the applicant's petitioners. The next issue was the notice dated so-and-so and so-and-so, respectively, read with the other notices as aforesaid issued by the principal respondent. The pleadings and the materials on record at that stage, the commission found that in the event of non-intervention of the intervention by the commission, by non-issuing of interim order against the said notices pending disposal of the main case, and the event of disconnecting supply of electricity to the applicant's petitioners, the commission held that irreparable injury may be caused to the applicant's petitioners. Thus, the apprehension of the applicant's petitioners that they may be displaced from the special tariff approved by the commission and may disconnect power supply is well founded, and as such, irreparable injury may be caused to the applicant's petitioners was also made out in favor of the applicant's petitioners. Besides, apprehension of multiplicity of proceedings may arise. Thus, where prima facie case and irreparable injury is made out in favor of the applicant's petitioners, balance of inconvenience follows. Thus, after detailed hearing and cross-examination, the commission passed an order dated 5/12 so-and-so, which is as follows.
This 5/12 remains unchallenged till now.
Lordships.
Yes, okay.
Also, the matter at hand being purely an issue of revenue, this is a reproduction of this. I can just read it.
Yes.
Also, the matter at hand being purely an issue of revenue, no prejudice would be caused to the principal respondent if the ex parte ad interim order dated 13/10/2022 is made absolute, As at the final hearing of the main petition, if the applicant's petitioners ultimately fail, the principal respondent can be adequately compensated by directing the petitioners to pay arrear additional amount from the date of the notice, which may be due as per the rates of normal tariff or otherwise as demanded by the principal respondent. And hence we find that no prejudice would be caused to the principal respondent by interim orders at this stage. Rather, it would help in proper disposal of the main petition. Accordingly, considering all the facts, my lords, I will just put up the main petitions. Para 22, my lords. On disposal of IA number so-and-so, the main case, vide MSCRC case number so-and-so of the petitioners was put up and passed an order on the same day, that is 5/12/2022, which is as follows. Petition put up today for disposal of so-and-so. As per pleadings, there is disputed facts about maintaining minimum average load factor of 68% by the petitioners as per MOU. Therefore, in exercise of provisions of Section 128 of the Electricity Act, this commission appoints she so-and-so to find out the actual facts. My lords, then this is the terms of reference. The CGRF may take a reference to the MOU by so-and-so, so-and-so. CGRF may hold its sitting for investigating, inquiring findings of fact at any appropriate place, but within Shillong, and the same shall be intimated to the parties before holding investigation by specifying the place, date and time. Further, CGRF is to find out the above facts supported by documentary evidence, but may also record oral evidence of the parties. Equal opportunity shall be given to the parties and also may be represented by the respective counsel. The CGRF shall submit the report in writing with all the documents on or before 15th of February 2022. Well, I'll skip this. The chairman CGRF Shillong, after obtaining extension of the time, submitted its report on 15/3/2023 and the same was intimated to the parties for the response. At this stage, it will be apt to recall that the state, the principal respondent number 2, preferred MC number so-and-so and WPC number so-and-so before the Honorable High Court of Meghalaya, challenging the impugned order dated 5/12/2022 in IA number so-and-so. Well, it's division bench order. Again, the principal respondent against
that he read earlier, yes.
My lords. However, the Honorable High Court of Meghalaya, by its decision dated 31/12/2023, disposed of the writ petition on the ground that the matter has been rendered infructuous in view of the order dated 16/12/2022. This is the order passed by your lordships, my lords. Passed by the division bench of the Honorable High Court in so-and-so. Finally, the principal respondent number 2 preferred special leave petition before the Honorable Supreme Court of India against final judgment passed by so-and-so. The Honorable Apex Court dismissed SLP as withdrawn. The purpose of narrating the above facts and circumstances are some of the reasons for causing delay in the final disposal of the main case, vide MSCRC case number so-and-so. Beside, it would be proper to say that the order dated 5/12/2022 passed in IA case number so-and-so by the Commission has attained finality as it has not been displaced by appropriate authority forum. Meantime, the present petitioners filed review petitions by so-and-so against the tariff order for financial year 2023-2024, where the petitioners are aware that non-inclusion incorporation of the special tariff in the tariff order for financial year 2023-24 is an error apparent on the face of the tariff order dated so-and-so, and as such, the petitioner applicant sought for incorporation of the special tariff as per the MOU. Along with the review petition, the petitioners applicants filed the present interlocutory applications alleging that the principal respondent threatened to disconnect supply of electricity by issuing notices. The principal applicants also aware inter alia that in spite of the order dated so-and-so passed in so-and-so, the respondent again issued notice dated 1/6/2023 and 2/6/2023 respectively for disconnection of power supply in default of payment of the current bill for the month of April 2023, which is in breach of the order dated 5/12/2022 passed in so-and-so. But these interlocutory applications are taken up for hearing as IA case number so-and-so. The petitioners applicants aver that the bill generated by the principal respondent is based on the tariff order for financial year 23-24, whereas the principal respondent should have generated the bill under the rate of special tariff in view of the order dated 5/12/2022. Nevertheless, the applicants petitioners submit that they paid the electricity bills on 35 so-and-so. Thus, the petitioners applicants aware that the matter relating to special tariff is seized off pending adjudication, and in view of the order dated 5/12/2022 passed by this commission, there was no occasion for the principal respondent to issue notice dated so-and-so, thereby demanding bill payment and threatening disconnection of electricity supply. Hence, pray to stay operation of notice dated so-and-so and so-and-so issued by the principal respondent, restrain the principal respondent from disconnecting power supply of electricity to the applicant's plant or restore supply in the event of disconnection. Whereas the principal respondent filed written objections in the form of counter affidavit denying the entire averments of the applicants and states that the petitioner's applicant should be dismissed as interim applications has become infructuous since the applicant's petitioners had complied with the notice dated so-and-so by making payment. Hence, continuance of lists would amount to flogging of a dead horse, cited so-and-so. Accordingly, the principal respondent prays that the commission may not be granted any relief as prayed by the petitioners. Parties and the learned counsels were heard at length, perused and examined the materials on record. Firstly, the order dated 5/12/2022 is subsisting till date and is very much in operation, and that the order dated 5/12/2022 shall continue to operate till disposal of the main case. Whereas the principal respondents are restrained from disconnecting supply of electricity, the principal respondent may recover due of energy consumed by the petitioner's applicants based on the said special tariff rate approved by this commission and also incorporated in the MOU and tariff for the financial year 2022-23, and the arrear, if any, payable by the petitioner's applicants shall be subject to the outcome of the main case. Thus, the order dated 5/12/2022 is crystal clear and self-explanatory. Besides, under the said approved MOU, the initial period is for 3 years, which may extend mutual consent with the approval of MSC, RC. The relevant clause is, my lords, reproduced. I'll skip this. Then para 33, my lords. 32, I'm sorry. That as per the order dated 9/10/2020 passed in MSCRC case number, the actual period commences, not relevant, my lords. Para 33. Secondly, there is no dispute of the fact that the main case, vide MSCRC case number so-and-so, is pending between the parties, which relates to the termination of MOU. Thirdly, most importantly, in order to avoid misrepresentations of the order dated 5/12/2022, it is hereby clarified that where there is a list pendants and an interim order dated 5/12/2022 passed in IA case number so-and-so is subsisting, which shall operate till disposal of the main case, it is categorically made clear that irrespective of incorporation or non-incorporation, non-inclusion of special tariff in the tariff order for financial year 2022-23 or otherwise does not matter, as it is redundant, as the issue is seized off by way of adjudication in the main case, and as such the principal respondent as well as the petitioner's applicants have to strictly adhere to the order dated 5/12/2022 passed in IA case number so-and-so. Fourthly, from the pleadings of the principal respondent acknowledged issuance of above disconnection notice dated so-and-so and so-and-so respectively for non-payment of bill, which was generated as per the normal tariff order for HT and EHT for financial year 2023-2023, which is disobedience and breach of the order dated 5/12/2022 passed in IA case number so-and-so. However, the petitioner applicants at the time of hearing submit that they have paid the bills under protest. The bill receipts for payment are enclosed. Fifthly, as seen from the plea of the petitioner's applicants, no punitive action against the principal respondent number 2 for disobedience, breach, contempt or otherwise of the order dated so-and-so is sought, even though there is a plea of breach of principal respondent of the order dated 5/12/2022, which is supported by filing of the copy of disconnection notice letter dated so-and-so and so-and-so issued by the principal respondent. Thus, under the above facts and circumstances, in my considered view, considering in totality the plea of the petitioner's applicants, I find that the petitioner applicants are seeking enforcement of the order dated 5/12/2022 passed in IA case number so-and-so, which is permissible within the ambit of equity in law. Accordingly, in the result, it is hereby reiterated and ordered that the order dated 5/12/2022 passed in so-and-so is subsisting and shall operate till the disposal of the main case or till the order is set aside, modified, altered by a competent authority forum, or till the completion of the initial period of 3 years and subject to the outcome thereof, which is earlier, and until then, the party shall strictly adhere to the said order. The principal respondent number so-and-so shall generate bills at the rate of special tariff, and the principal applicant shall diligently make prompt payment for the energy consumed as per the rate of special tariff till disposal of the main case. The principal respondent number 2 shall not disconnect power supply to the petitioner's applicants. However, in the event of default of payment for the periodical current bill by the petitioner's applicants under the special tariff rate, the principal respondent may resort to general provisions of Electricity Act in regards to issue of notice of disconnection. The arrear, if any, shall be subject to the outcome of the main case before parting of the credit records, so-and-so. Now, the issue here, my lords, your lordships, which is why I took the liberty of reading this entire order, is an essential fallout of the order dated 5/12/2022. Now, once your lordships have taken a view, my lords, that if at all you are aggrieved by this order, you go before the appropriate forum. Where is the question of maintaining a writ petition before this honorable court?
Yes.
Electricity Act.
Electricity Act.
The other aspect of the matter is, my lords, if I may now take your lordships, what was submitted by the learned Advocate General is, my lords,
they have not submitted anything so far.
No, you conceded that it was filed. This will be filed under 227. This would be treated as under 227.
Yes.
That they have made it clear before your lordships.
Yes. We'll take a 227. Yes.
My lords, the law, my lords, as I humbly understand it, is very clear that when there is a provision of appeal, my lords, remedy of revision cannot be resorted to by any of the parties, especially before a constitutional court.
Okay, yes, Mr. Amit Kumar.
Yes, sir.
Lordship,
Well, it's my friend is here for.
Lordship, my senior.
Or you also have to compound a submission.
Lordship, I'll just supplement his submissions by placing 2-3 judgments on whatever he has spoken. I will not touch the facts, nothing.
See, the thing is that now, you see,
Lordship.
you have to limit this discourse to one thing.
Yes, ma'am.
Now, coming before a writ court
Yes, ma'am.
is to, point out the irregularities and illegalities which were committed by the tribunal in the procedure,
Yes, ma'am.
which by 227 now is seeking to correct by exercise supervisory jurisdiction of this court.
Yes, ma'am.
Now, maybe some challenge the conduct of proceedings, the manner in which it's been done.
Yes,
if I remember correctly, they have not been heard, or something like that. So anyway, so what do you have to say? Is it in substance with regard to appeal, or is it with regard to the procedural,
Not on the procedure, my lord, on the maintainability of the writ of the petition itself.
Okay.
Now they call it, now they adopting it as a revision. Lordship.
You appearing to MSERC?
Yes, ma'am.
Why are you appearing?
We've been made a party because in our absence,
you're a quasi-judicial body.
Lordship, in our absence, Lordship will kindly appreciate there is no writ petition that lies. They cannot enter this honourable court, my lord, in our absence. So since we've been made a party, there are allegations which have been made against us. It is our duty, my lord, just to point out certain aspects, just 2 aspects, my lord. The fact that, number 1, the fact that this petition itself is not maintainable.
Okay.
I'll restrict myself to that.
Yes. Yes.
My first point, my lord, would have been that 226 and 227 cannot be taken together. That point has been cleared, my lord. They are adopting it as a 227 petition. Even if they are adopting it as a 227 petition, my lord, the scope of 227 is a very limited scope, my lord. Lordship is well aware of the law. With Lordship's indulgence, I'll just place the law. So I can have no problem. A small compilation, my lord, page 5 of this compilation.
Please give me the citation so that
I'll do that. I'll do that.
I would have been ready with the matter. I don't have compilation with me now. How will I respond to you?
We were hoping that Leonard Senior would be present amongst us today, but I've supplied a copy. I've supplied a hard copy.
I have been supplying all the citations in advance to you before hearing.
Lordship, I'll place the law. If my senior requires time to respond on these judgments, that would be up to him, my lord.
Then it's better we see. This court's taking up this matter, in the hope that we will, we can pass some orders today.
I'm reading just one line from these judgments.
As a matter of fact, your lordships had on some occasions noted that all of us should be physically present here. I think the matter was adjourned on that.
My friend has relied on the judgment. Mr. Paul has finished his argument. Mr. Jindal is on his leg. So therefore now, if you are relying on the judgment, please give me the copy so that I can meet the argument.
I've given a copy, sir. I've handed over a copy. As I said,
in all fairness,
Lordship will kindly allow me. As I said, I'll be reading just one line from these.
No, it's fine. It's fine. You have given the court. I mean, the court on its own can peruse also. It is not really, this is a. The only thing is that you should not put aside to disadvantage.
And Lordship,
I mean, even it may not be, but they feel they've been put at disadvantage.
Lordship will kindly allow me to point out, and without intending to sound rude about this, but this is the law. What I'm submitting, my lord, what I'm submitting is the law, and there is a requirement. If I'm submitting a pleading to give copies, I'm not required to give copies of the law, my lord. But out of courtesy, out of practice.
But that is courtesy now. You see.
Yes, my lord. I completely agree. So, Lordship will allow me to place the law if there is a requirement on the part of the petitioner to take some time for that. Very well, my lord. Page 5, my lord. Page 5, my lord. 2010 8 SCC 329.
Yes.
Para 49 of this judgment, my lord. On the next page itself. I'll read, my lord. On an analysis of the aforesaid decisions of this court, the following principles on the exercise of High Court's jurisdiction under Article 227 of the Constitution may be formulated. Clause A. A petition under Article 226 of the Constitution is different from a petition under 227. The mode of exercise of power by the High Court under these two articles is also different. I'll jump to C, my lord. High courts cannot, at the drop of a hat, in exercise of its power of superintendence under 227 of the Constitution, interfere with the orders of tribunals or court inferior to it, nor can it, in exercise of this power, act as a court of appeal over the orders of the court or tribunal subordinate to it. In cases where an alternative statutory mode of redressal has been provided, that would also operate as a restraint on the exercise of powers by the High Court. I'll jump again, my lord, to F. In order to ensure that law is followed by such tribunals and courts by exercising jurisdiction which is vested in them and not by declining to exercise the jurisdiction which is vested in them, G. Apart from the situations pointed in E and F, High Court can interfere in the exercise of its power of superintendence when there has been a patent perversity in the orders of the tribunals and courts subordinate to it, or where there has been a gross and manifest failure of justice or the basic principles of natural justice have been flouted, my lord. I stress most of all on C, my lord. When there is an alternative remedy provided, 227 would not be the forum, my lord. In a similar vein, my lord, if lordship kindly looks at page 13, and this is something learned senior appearing with me, my lord, had already touched upon. Page 13, 2003, 3 SCC 524. Relevant paragraph 6, my lord. The right of appeal, I'll read, my lord. The right of appeal is a statutory right, and where the law provides remedy by filing an appeal on limited grounds, the grounds of challenge cannot be enlarged by filing a petition under 226, 227 of the Constitution on the premise that the insurer had limited grounds available for challenging the award given by the tribunal. Section 149(2) of the Act limits the insurer to file an appeal on those enumerated grounds, and the appeal being a product of the statute, it is not open to an insurer to take any plea other than those provided under section 149(2) of the Act, see so and so. This being the legal position, the petition filed under Article 227 of the Constitution by the insurer was wholly misconceived. This is important. Where a statutory right to file an appeal has been provided for, it is not open to the High Court to entertain a petition under 227 of the Constitution. Where there is a statutory right of appeal, in our case under section 111 of the Electricity Act, with all respect, my lord, lordship may not exercise 227 powers. Last point, my lord, I believe, going through the petition, there is a ground which has been raised to try and enter this honorable court, on the basis of which to try and enter this honorable court, stating that commission acted without jurisdiction. Without examining the merits of that contention, my lord, even if there is an allegation of absence of jurisdiction of the lower forum, that absence of jurisdiction itself becomes a ground of appeal, my lord. The absence of jurisdiction cannot be made as an excuse to invoke 227 jurisdiction. In this connection, my lord, two judgments, page 16 of the compilation, my lord.
Page number?
16, 16.
Okay.
This is a full bench judgment of the Honorable Allahabad High Court, 1980 SCC Online, Allahabad 865. Relevant para 11. I'll read, my lord.
Yeah.
In Commissioner of Sales Tax versus so and so, it was held. Service of notice under section so and so of the UP Sales Tax Act is a condition precedent to valid exercise of power under that provision, and it goes to the very jurisdiction of the officer. The point which goes to the root of the matter or affects the very existence of jurisdiction of authority can be raised at any time, be it in appeal or revision. This is one, my lord. This is a High Court judgment. Better yet, my lord, is a Supreme Court judgment on the same issue on the next page, my lord. 1951 SCC 217. Relevant para 37, my lord. It is well settled, I'll read, my lord, 37. It is well settled that if a court acts without jurisdiction, its decision can be challenged in the same way as it would have been challenged if it had acted with jurisdiction. That is, an appeal would lie to the court to which it would lie if its order was with jurisdiction. So even if there is an allegation, my lord, lordship has found it para 37.
Yes, yes. No, I'm just looking if I could get the preliminary facts of the case, but that's not there.
Sorry, my lord. This was prepared in a hurry. I can supply it if lordship requires, my lord. I'll read again, my lord. It is well settled.
No, yes, I've heard it. Yes.
So the point is very clear, my lord, that even if there is an allegation of absence of jurisdiction, which appears to be the allegation present.
Is that the only allegation in the writ petition? No. What other grounds have they raised?
That is the allegation based on which they enter this honourable court, my lord. So honourable High Court, stating that 227 should be invoked, should be exercised, because there was a complete absence of jurisdiction, apparently, my lord. Even if there is an allegation of absence of jurisdiction, that allegation itself is a ground of appeal. In cases, my lord, where there is no appeal provided, for example, that in those peculiar cases, situations, 227 may be the only remedy available. But when there is a statutory right of appeal, law is very clear, my lord, that statutory right has to be exercised rather than 227, my lord.
Okay.
On the facts, etc., my lord, I should not make submissions.
Yes, sir. Now, the judgments have been cited, and I'm sure, my lord, judgments are distinguishable in fact. So, therefore, my lord, I need to go through the judgments and place the matter, my lord. But your lordship may take note of one fact, that MSCRC is a formal party, and MSCRC is a formal party which is supporting the
case of the
supporting the respondents here. Now, being a formal party and coming and in support of the respondents' private electricity consumers, my lord, this itself shows the inherent bias on the part of MSCRC. My lord, we make the
I don't think with the general submissions they change on that. He's also showing that the justifiability of the orders and whether
Respect, my lord, Mr. Jindal is saying that this writ petition is not maintainable. That's the
correct.
Sum and substance.
So that shows their inherent bias. I mean,
why I say so, my lord, because this can be argued by the private electricity consumer. The corporation or judge will not come and support the judgment. MSCRC is coming and supporting the judgment is itself shows, my lord, that there is an inherent bias in favor of the private. So therefore, on this ground alone, your lordship may exercise the jurisdiction. Because here is a case, my lord, here is a case where the MSCRC has not disputed the fact. My first and foremost contention was, my lord, that these IAs have not been listed for hearing on 4th July. The lordship has, in my second paragraph of the writ petition, I have said so, and this has not been denied by the respondents, my lord. Therefore, this in itself shows that it is a gross violation of principle of natural justice. My friend has read out in paragraph just now. I heard. I have to go through the judgment.
Now, one thing coming back. See, one thing, Mr. Mikuma, just to clear the mind of the court. The thing is that if this all these proceedings, they're stemming from one orders 5/12/2022. It has gone through the entire thing up to Supreme Court.
It is a false statement, my lord. It is an incorrect false statement. It's a cobweb they have woven before your lordship to show that it is originating from 5th December 2022 order. And they are not telling your lordship.
No, I'm going from the order itself. I'm speaking not from the submissions. I'm saying the order that
is why I saw how they are back. That is why I'm showing, my lord, that how this order has been woven to show that this is emerging from 5/12/2022 order. 5/12/20. Your lordship, kindly keep in mind one aspect. Very simple. I will show from their own document. This MOU was valid for a period of 3 years. And now he will say
first just touch on the maintainability aspect. I understand that you're concerned about the financial year 22-23 to say that the MOU will not cover these subsequent years, and so raising a tariff as per the current tariff is like justified. The thing is that now the first thing you have to address is their objections as to the maintainability of the writ petition due to the presence of alternate remedy, number one, and number two, you only have to show, demonstrate for this court that why you've come by 227 is because of these, what do you call it, the infractions of the tribunal, which left you no other remedy but to come here for correction of the process, then or what do you say, course correction, and so that the matter may be like will be on even keel. That's all. If that's limited interference that this court will go into also. Maybe you'll not even go to the merits also. But only we'll go into procedural aspect of whether it acted in excess of jurisdiction or is it procedural impropriety. Those are the things. We don't want to swim all over the place.
And within the ambit and scope of Article 227, my lord, I will not digress or I will not go out of Article 227, my lord.
No, you made, first point is that you made a point on bias. You said that the very fact that MSERC has appointed a counsel and appeared before this court, being only a formal party to defend the order, that has to be taken cognizance of by this court to show that, there's a whatever, I don't have any words to describe.
My lord, I will not hesitate in saying collusion. Second, my lord, is that
collusion. That's very strong.
Collusion. I am strong because I will show from the material. I will show from the material, my lord. I will show from the material which was there. That's it. I would have refrained from using this word, but I am compelled to use this word, my lord. First is, my lord, that the very presence of MSERC. Second is, my lord, there is no denial that these IAs have not been listed for hearing.
See, Mr. Ambedkar, coming back to the inherent bias, now the statements that you're making have a very, very, that means you're questioning the very, the constitution of the tribunal and regard to the integrity of the presiding officer itself.
Yes, your lordship, kindly see your lordship's order. I have placed on
the person would have to be made a party.
Your lordship's order. I am saying so with full responsibility.
If this is the stance, then they would have to make this is a very serious allegation.
Very serious.
If it is a very serious allegation, that the person concerned has to be made a party.
Paul.
I am saying so with full responsibility, my lord. Why I am saying so, my lord? Your lordship would recall the matter travelled earlier against the order of MSERC and we challenged that order, and your lordship has passed the order on 21st February 2022. My lord, I will place why I am saying so. In 21st February 22 order, what Mr. Paul said, that the grievance of the individual consumer cannot be heard by the MSERC, and your lordship has recorded Mr. Paul's statement in the order. Your lordship has also recorded that single member cannot decide because it is wholly without jurisdiction, and on that ground that was also conceded, my lord. Now kindly see, after your lordship order, what they are trying to say that no, there was a stay which was operating in MOU, and therefore in line of MOU they have obtained the order. My first is, your lordship, my friend has placed before your lordship division bench order, saying that this 5/12/22 order has attained finality and it has not been challenged. No appeal has been filed. My lord, these facts have been placed. I will place the facts also. Your lordship would recall that there is the review of tariff order has taken place. A tariff was reviewed. In tariff, your lordship will kindly see the order passed by the commission on 7th June 2023, my lord. Kindly see the order passed by MSERC, whereby the tariff was fixed. Page, your lordship will see at page 55, it starts, my lord.
Yes.
Page 55. And you have to always keep in mind there is no denial that these IAs have been heard, and the commission is recording that, and the IAs have been heard on 4th July in the order. What more I have to say, my lord? I have shown videograph. I have shown the text of the entire video script where the commission chairman is saying, we'll give you time for filing reply to the IA. That is the material which I am using against the commission, my lord. That is your lordship, kindly see page 55. 55 is, my lord, is the tariff order passed by the commission on 23/24, my lord. The page 55 itself indicates, my lord. And then your lordship will see at page 123, my lord. There is no reference of a special tariff. There is no reference for a special tariff by the commission for 23/24. My lord your lordship would recall the order was pertaining to MOU period by commission. Now, if I take the argument of my friend to be correct, my lord, in terms of MOU, till the time the MOU is set aside or MOU is for perpetuity. What my friend is saying, MOU is for perpetuity. Commission has passed the tariff order in which there is no scope of a special tariff. And what happens, my lord? My friend files an IA at 217, my lord. 217. Kindly see in the very tariff order, my lord. And very tariff order, my lord, my friend filed an IA which is at 217 and extra P4, my lord.
Yes.
214, my lord. And you also will see grounds at 225. Ground number 1. For an error apparent on the face of record has crept into the tariff order of 11/4/23, inasmuch as this Honorable Commission had fixed a special tariff for a period of 3 years, and the said period would expire only in October 23. Same being an integral part of the present existing tariff was not taken into consideration by the Commission while fixing the tariff for present 23-24. So as per then, as per the petitioner, my lord, what he says that this special tariff will expire in October 23, my lord. October 23, as per the petitioner also, my lord, and on this, my lord, and you also will see prayer at 227. Admit the review petition on tariff order of Commission of 11th April 23 as submitted herewith, condone any inadvertent omission, etc. So what is being prayed, my lord, is that in terms of tariff order, we are raising the tariff. My friend's client's case is, my lord, that the special tariff is valid till October 23. We are sitting in October, my lord. We are sitting in October. As per him, maximum period is October only, October 23. And there is no order passed in the review petition, my lord. There is no order passed in the review petition. Review has not even been allowed.
So this is an IA or review?
Review, this is review. This is the review. And orders have been, I will show how they are juggling. This is jugglery which is happening in commission. How, that is why I am using very strong terms. I always refrain and maintain, my lord. But I am really sorry how this is happening and how this the public interest is being compromised at every stage. Kindly see the review. It is their review. In review, they are in review to tariff order. The consumer is saying that please, this special tariff is valid till October, and please review tariff order. There is no order passed in the review. Now, what they cleverly do, my lord, they realize that look, now we have to come out with some argument. That look, there was a stay which was operating in, and that order has attained finality up to Supreme Court. Therefore, I will file IA in the disposed of matter. Kindly see IA which was disposed of matter. What was the direction passed in that matter? I will show, my lord.
Where's IA?
Your lordship will see the IA. Your lordship will kindly see 312, my lord. 5 December order at 312. They are taking the public interest for right. I will say so with respect, my lord. Petition is put up, your lordship 312, your lordship 5th December. Petition is put up today on disposal of IA 1/22, so and so.
3-1?
As per the plea.
Okay.
T312. This is the order passed by the Commission on 5th December 22. I have shown, my lord, that first I have want that there is a bias, inherent bias in supporting the illegal order. Second, my lord, the IAs which so-called IAs have not been listed. I will show my averment, my pleading, everything. That has not been denied. Even Mr. Paul has not denied in his argument. Without listing the IA, they are passing the order. They are passing the order and they are saying.
I have not touched on the merits of the matter, my lords.
This is merit, my lord.
Mr. Kumar, Mr. Arvind General, then we'll hear you in totality then.
Yes, your lordship.
Otherwise, this way we won't do, Mr. Paul.
The order itself says that they filed a written objection.
Please hear me in totality. I will meet
your lordships, if your lordships are deciding that this matter is maintainable, my lords, then it's a different issue. The lordships would have to first deal with the issue of maintainability.
No, there are certain things, Mr. Paul, that's tickled the mind of the court. with regard to, especially the review application has been filed, which is on a pointed submission by you in the grounds itself that the special tariff will, you're asking for review of the special tariff order to include.
Well, that review is pending. That review is not
now. How was the review tackled? It's not subject matter. But with regard to the filing of the IAs and in Mr. Amit Kumar is trying to show that
the main petition is pending.
Exactly, that's the thing. The 11.
If I may, it's like this, Millets. There is a writ petition pending before your lordships, Millets. Your lordships pass some interim orders on the miscellaneous case filed by the main writ petition. In the meantime, Millets, the subject matter of that matter.
No, but the submission they made is that your IAs were filed and they were not listed for consideration.
Millets.
And without being listed for consideration,
how was an objection
the tribunal has taken up the matter.
How was an objection filed on that?
Objection, I will show that objection was filed subsequently and even in the video clipping, my lord, chairman.
In the main review petition, my lords, your lordships, they have said that the review will be heard separately. That review is not even there.
If the petitioner is wrong, heavy cost would be imposed, my lord, because they cannot use this forum for misusing the power of the.
My lords, the first question that I ask myself again is, before we get into the merits of the entire matter, whether your lordship would decide this issue.
We're not going to merits. The only thing is that even a maintainability, like the sequence of facts, to decide maintainability also,
may I make it a little more clear?
If it disturbs the mind of the court with regard to the procedure adopted by the tribunal, then under supervisory jurisdiction, I'm afraid the court will have to interfere.
Make it a little more clearer. Your lordship will see what is the prayer in the revision petition. The prayer in the revision petition is, the order of July 2023 be set aside.
Heard learned counsels for the parties. The hearing is inconclusive, especially the point of maintainability listed after puja vacation for final disposal. For on the ground, we'll hear it because there's something that disturbs the court. I'll go through the records myself.
Logic.
Yes, sir.
Otherwise, there's something.
Yes, using such terms of collusion.
Exactly. That's what disturbs the mind of the court, Mr. Paul.
Why would the state
see why? That is why Mr. Paul disturbs the mind of the court. If the submission starts inherent bias on the part of Mr. General's client or the tribunal and also collusion, that's very serious. The court has examined that. If we examine it only prima facie on the face of the records itself, then fine, we can decide. But if such he's the Advocate General after all. Whatever he said, even as a member of as a counsel appearing for
my lords, that is going to be a little personal. I won't understand whether the Advocate General is appearing or a learned senior advocate is appearing. Because this is a corporation, my lords, it's not the state.
I'm pointing out as a humble member of the bar that this is how.
So it is not the Advocate General, my lords. That's very aptly put by my learned senior friend.
But that's very.
So simply, my lords, picking up some big words from the dictionary, my lords, will not essentially confer jurisdiction on this.
Even that, but some have been made in open court, Mr. Paul, about collusion and inherent bias. We'll have to address it.
In that event, I would, as is rightly fallen from your lordships,
we'll have to address it.
They would have to buttress this contention.
And the court have to address it. They'll have to address it.
If they cannot, my lords,
because if
consequences would have to follow.
Of course.
I will suffer the cost.
It's not a question of costs. We cannot get away by making these big statements and just simply pay costs.
Because that cost. If these statements hadn't come in, we would have examined. I would have passed order today itself.
Mind us that cost is not going to be paid by somebody out of his own salary. The cost would be paid out of the taxpayers' money.
No, it's not that. You see, it amounts.
So whoever has filed the affidavit,
one thing, Mr. Paul, listen, it reflects on the presiding officer sitting there. And if it's an open court is made, that means that is a sort of very.
The person against whom the allegation is made.
You're impugning the character.
The person against whom the allegation is made was the Chief Secretary of the state, appointed by the state.
Singly, your lordship's order is there that he cannot hear the matter singly, and that order is violated in.
We'll hear you. But Mr. Advocate General, Mr. Amit Kumar, Mr. Amit Kumar, since you are appearing as the senior counsel, you have to substantiate your allegations.
Lordship, as far as the allegation of collusion, at least on that I should be heard, my lord, or even for that, my senior will have an objection to me.
See, that is I'm not having objections. I was just curious that why are you supporting your order? That's the only thing on the maintainability. But if other submissions have come, which the court has to address, and the court noted that one is inherent bias, and stroke collusion. So that we'll have to address.
My only
It's not-
intent,
it's not
my
such
only
a-
intention, my lord, my only intention was to, to use words.
You have become the fly in the ointment. If you entered, it would have been over by now.
We shouldn't have been made a party. We shouldn't have been made a party. It is our job. It is our job.
Mr. Paul is doing a good job sailing nicely along, but
Second call.
But I would say, Malaj, as somebody not on the merits of this matter, these kind of expressions of collusion, inherent bias against an institution,
that is why,
Malaj,
Mr.
is
Paul,
not correct.
that is why we'll have to express an
Malaj,
order
because
also whether
in one breath we make an allegation of collusion, inherent bias, or on the second breath, my lords, the order by which the tariff is fixed by that very same commission, I will go and charge the tariff on that. So when the order suits me, my lords, it's perfect. When the order doesn't suit me, then I will make these statements before this bar. It's
Okay,
very
next matter.
unfortunate.
Second call. Supplementary list item number 2.
very disturbing, Mr. Paul, very disturbing.
It's very disturbing, my lords. When an order suits me, my lords, it's perfect. Because they are taking...
Disturbing in the sense that, it's a regulatory commission. Anyway.
My lords, because the tariff is being charged by them, the very argument of Mr. Amit Kumar, my lords, because they are charging the tariff under the tariff passed by this very same commission against whom they are making allegations. So that time, since the order suits them, it is perfectly fine.
And we will hear you, yes. Yes.
Well, can this kind of blowing hot and cold be permitted?
No, we'll handle it, Mr. Paul, don't worry. The court knows what
Second
to do.
call.
Yes. Mr. Jindal has become create the whole pitch. Yes.
Supplementary list item number 2.
Yes, where's the petitioner? Convert. Just keep convert. Leave it there.
2 and 4
Yes.
or 1 and 4.
Yes, number 2. Who's the petitioner? Both boy. Who's the what is she? Who's the petitioner?
Mr. Manta, Your Lordship.
Mr. Manta is here.
Mr. Manta is not here.
Mr. Manta is.
SP Manta, M Walang, SG3, M Lingdo, PL Yadav, D Susni, D Pala, P Shalla, I Das, SE Kharbuki, LDN Thanki, D Franken, DC Pasa. They are around the whole 11 or something. What to do?
And then after vacation, Your Lordship.
Let's keep it pending. If they come, we'll pick it up. Yes, since the last day.
Lordship.
Any interim orders they're asking for?
Lordship, yes.
Then we'll let them come. Mr. Abraham, you kindly inform. Otherwise,
Item number 4.
Kaju. Now, suppose nobody there. None appears for the petitioner. We'll keep it. If no one appears second round, we'll after the motion, then we'll adjourn it.
Hearing. Supplementary list 15.
Where's Mr. Abraham? You got instructions or not?
I have received instruction
that the
has it been approved?
Resolution of the managing committee dated 3rd September has been received by the department, and before final approval could be given, there was a stay order from this honorable court, so we could not give any approval. And thereafter, before that we have even forwarded to the government for approval. It is now pending before the
Mr. Abraham instruction submits that the proposal as put up by the managing committee has not been approved. In our view, the matter, this is matter after.
Well, may I just make a small prayer?
It's not been approved.
Well, it's not been approved.
Yes.
It is pending with them. Let them take a final decision on the matter, Malaj. Not in my favor, not in their favor, whoever's favor. Let the government take a decision.
We could not take. The managing committee is expiring on 31st.
Yes, okay.
The Lordship
after
will have it
vacations.
It was die natural death, Mr.
Lordship.
Well, natural deaths In courts do not happen, your lordships know.
You've done your job for your client, but it's not been approved. So that's the thing.
No, I was only praying, my lord, since it is pending.
It has been approved. You would have got the order, Mr.
No,
Paul.
I am only saying that since it is pending with them, let them take a decision, my lords.
But there was that stay order was that is
doesn't matter. Yes, you take a chance. A new committee.
Main list 19.
What stage is this one? We'll do this some other day, Mr. Vicent.
Immediately after vacation.
He's done a good job of stopping you. Stalling the hearing.
The only issue remains here, man, whether they were receiving last occasion lordship.
That's the instructions have to come with.
Financial aids from the central government.
Whether in paying those teachers that approved scale as given in that regulation, the funds are coming from this, from how much percentage?
80-20.
80-20.
For 5 years.
You have got instructions on that.
I've received additional instructions, my lord, but the fact is, my lord, this is not before this honorable court. Now, if I'm allowed to file an affidavit, my lord.
How many affidavits, my lord? This will be the third affidavit.
No, because otherwise I'll just
Only
have
thing, my
to...
lord, for 5 years, whether that 80% has been received or not. This is to be for 5 years. After 5 years, entire burden is taken over.
We had come down to that point only where he repeated that thing. Yes.
Well,
This one, he can just make a oral submission whether he is receiving.
After the records I have received, my lord, some part of my submissions will have to go, my lord. But because as this is not before this honorable court, my lord, if this honorable court permits...
Mr. K.B. Bhattacharjee submits that additional instructions have been received, which he prays that he be allowed to place by way of affidavit. Considering that the court will be closed for 1 week, if the affidavit will be filed within honorary opening, failing which the same will not be accepted.
My lord, may I request for 2 weeks?
No, madam, no.
So that I don't...
Well, what he's doing,
My lord,
even I feel embarrassed because of his conduct.
By 31st October.
Okay.
Failing which, he will accept affidavit. Yes.
27.
See, we allow these things. It's only for the ends of justice only. It's
Exactly,
not like, but we can't make the whole process be dislocated.
Exactly,
Like this court also, we just wasting judicial time. If we hear a matter, we want to conclude it.
Exactly,
that's the thing.
Exactly, my lord. That is exactly why I want to place this.
What he's doing is conduct.
That's part of his advocacy.
I feel embarrassing.
My lord, my senior may be angry, but nevertheless, my lord, this is necessary for enforcement.
These are MECL matters.
These are things MECL matter, my lord. I have a chat, my lord. As per leave encashment benefit is concerned, my lord.
My lord, if I can make a small prayer, my lord.
Leave encashment benefit.
My lord, it's been...
yes.
It's been long time, my lord. The
Total
matter is
amount
pending.
due and payable under against the leave encashment benefit is, my lord, 58 crore rupees, my lord. Against 58 crore rupees, my lord, we have paid 2 installments, my lord, amounting to 28 crore rupees, my lord. Now balance is 28 crore rupees, my lord, and we are trying to clear, my lord. There are 8.
Have you have a copy of the list?
No, my lord.
Please share the list with my friend.
Yes, Mr. The Senior Counsel for the Respondent Corporation, Mr. A. Kumar, has produced a list. What is LEB?
Leave encashment benefits.
Indicating the leave encashment benefits with effect March 2017 up to May 2023, which has been advanced to the employees, which includes the petitioners herein. A copy of the same is also made over to the counsel for the petitioner.
My lord, in the meantime, if we can make just a small submission, my lord.
Yes.
My lord, even in the newspaper also, my lord, there are reports that some of the amount has been already released. My only small submission is that, my lord, even the Christmas also is coming. If my lord can...
Where puja hasn't been coming, Christmas is
my lord,
coming.
Puja is, my lord, too early. It is not possible. If my lord can dispose these cases with the direction that
before Christmas,
within 1 month, my lord, to clear this.
Let it come after puja vacation to examine the list.
My lord.
Yes. List is matter after vacation. Yes.
We try to clear the amount. We have paid 28 crore rupees, my lord. In August, by August, we have paid. We will clear the. We are trying to clear. As and when fund is coming, we are paying.
Yes.
Item number 2.
No one's come for the motions.
It'll come on 31st, Your Lordship. Nobody's.
None appears for the petition. This is a matter on 31st October. All the motions, yes.
So apologies, Your Lordship. So item number 2, sir. Your Lordship.
Yes.
Item number 2.
Where's the counsels from the morning? You're not here. You were here in the morning.
Yes, sir, we were here, sir.
You're moving the matter.
Yes, sir.
Okay, what's the matter about? Are you praying for the stay?
Yes, sir. Yes, Your Lordship, also that, sir.
Who's submitting?
I'm submitting on behalf of the petitioner number 1.
No, you or you?
So we are both, it's a
She's
connecting
from the
matter. We are both from the petitioner, plus...
Yes.
It's for the item number 3. Your
Yes.
Lordship.
Item number 3, this one? Yes. Number 2 first. Number 2. Who is the appeal number 2?
I'm appealing
Yes.
for...
What is your case?
So, Your Lordship, may I please, Your Lordship, this is an application under Article 226
Yes.
of the Constitution, filed a petitioner against challenging the appointment of respondent number 5 and 6.
Who 5 and 6? The apparent respondents. Okay, yes. Continue, yes.
As coaches, junior athletic coaches in the Department of Sports and Directorate of Sports and Youth Affairs, Government of Meghalaya. Your Lordship, there's an advertisement dated 14 November 2019 at Annexure 9, page 45. And
Page? Go slowly.
And
Don't
it's
get
to-
nervous. Yes. You sit down. What's your name?
Yes, sir.
Yes, you sit down. Let her submit it.
so, Your Lordship, there was an advertisement dated 14 November 2019 at Annexure 9.
Yes. Where's your post?
Pardon, Your
Which
Lordship?
serial number is your post? Which you have?
It's for the post of the junior athletic coaches.
Which page is that?
It's at page 45, Your Lordship.
Okay. Lecturer. No, which serial number of the advertisement is your job?
It's at serial number 8. The page is 47, serial number 8, Your Lordship.
Okay, for junior coaches. Right, okay.
Yes,
Then?
yeah. And petitioner having all the requisite
What is
qualifications.
this? Candidate should not be less than 18 years, more than 30 years with 5 years relaxation, so on, so on, so on, so. With national level achievements, medalist, no age limit for those who are. So that is the, and skill of pay, graduate any stream diploma sport from NSIS, Patiala or subsidiary institute. Okay. Yes. So what happened
There was
after that?
also a corrigendum, Your Lordship, is at page 53, 52. A corrigendum with regards to the.
Page?
It's at page 52, Your Lordship.
Okay. What does the corrigendum say?
The corrigendum, a proposed advertisement number MPSC advertisement 38//2019-2020-23/83 dated 14/11/2019 for the recruitment of the post of junior coaches in the following fields. One is for athletics and leadership, and then in the corrigendum hereby issued in view of classification received from Sports and Youth Department, Government of Meghalaya, the required qualification educational was graduate in any stream with diploma in sports and coaching from NSNIS Patiala or its subsidiary regional institute in the concerned discipline should be read as 12 plus with diploma in sport coaching in concerned discipline.
So they did away with this NIS Patiala.
Yes, Your Lordship.
Okay. Then what happened after that?
And then after the corrigendum was released, the petitioner was called for the interview, Your Lordship, via the letter dated 18 November 2022.
Yes, then?
Which is at Annexure 11, page 53. And then he sat for the interview on the 24th of November 2022. Your Lordship, the result was declared on 8 December 2022, which is at Annexure 12, page 54.
What is his name?
Pardon, Your Lordship?
Sylvester Lingdo.
Sylvester Lindo.
So you were not selected.
Yes, yes, Your Lordship.
Okay.
And then in the said notice, result notice, Your Lordship, the petitioner's name was not there, and being aggrieved, the petitioner has filed a letter of representation to the Director of Sports of Youth Affairs dated 19 December 2022 at Annexure 13 at page 55.
Okay. Then?
And the same was left unresponded by the concerned authority. And since the petitioner did not receive any response, aggrieved by the same, the petitioner has filed an RTI, and via reply dated 5th May 2023 at Annexure 14, page 59.
What did he say?
Asking for the marks of all the qualified candidates, which was never provided by the MPSC.
Yes.
And then, Your Lordship, there was also an RTI filed by one Shri Sanbor Rapsang, and which is at Annexure 15, page 60. And in the said RTI, the applicant has specifically asked for the list of institutions which is recognized by the sport department in order to be appointed as coaches in junior coaches athletics in the sports department. And then, Your Lordship, in the said RTI at Annexure 3, which is page 72, the concerned department has
Annexure
listed,
3, page 72.
which is Annexure 15, page 60, 72. I'm sorry, Your Lordship.
Page 60.
72, Your Lordship.
Yes.
And then in the said RTI, Your Lordship, only 4 institutions were listed as the one recognized by the sport department.
Okay.
And then, Your Lordship, the applicant, means the petitioner herein, he is a graduate, he holds diplomas from
one of those institutes.
Yes, Your Lordship. And whereas the respondent number 5 and 6, he
No, but
doesn't.
see, one thing, just stop a little bit. The thing is that with the corrigendum, the first one was required, it had written that graduate any stream with diploma in sports coaching from NS and IS Patiala or subsidiary regional institute of concerned discipline should be read. Now, earlier on, it's just from these recognized sports institutes, correct?
Yes, yes.
But then later on, they changed it to 10+2 diploma in sports coaching in a concerned discipline. That means your case is that they changed the advertisement
Yes,
to
Lordship.
include other people from other institutes.
Yes,
And
Lordship.
because of that, you've been deprived.
They have been deprived, Your Lordship.
Okay.
Because the
Yes. What is your name?
Sylvester Lindo
No, your name.
or Dabyanki Funkan.
Yes. Take down. Interim since the recommendation since December, they can't pass the orders now, and you have to issue notice to the private respondents.
Your Lordship, with regard to the Miss case, Your Lordship, I have only one prayer.
Yes.
That sorry, Your Lordship. That the matter to be disposed of, to be disposed of, Your Lordship, and the appointment order dated 8 December.
Be set aside and quashed.
Yes, Your Lordship.
Very good. Yes. Yes. Heard MSD Fedcon issue notice. Mr. ND Schreiler AG.
For 1 and 4, Your
also is
Lordship.
present on behalf of
R1 and 4.
Yes, 1 and 4. No further notice. Notice to go to respondents 2, 3, 5 and 6. Steps to be taken within 1 week. List after 3 weeks.
Only Your Lordship there.
Well done. Yes, your first time you appear.
Yes, Your Lordship.
Very good. Yes.
Maintainability, Your Lordship.
Doesn't matter. Let's take notice first. Whatever we have to object, you object later on. Yes. Yes. 3, same order.
Same order will follow, Your Lordship. Oblige.
Item number 4.
Well, Mr. Jha.
In fact, submission has been made before code number 4 that he's not coming today, something like that. I was there.
What do you have to say with this case, Mr.
Your Lordship, I've only been informed that to accept notice in the meantime, Your Lordship.
But how to accept notice when the petitioner's counsel is missing? This is the first case of courts come against where it come against warning letter asking him to lose weight. So whether orders can be issued to a soldier to lose weight? No.
Your Lordship, I cannot comment on that.
Yes, okay. Really, it is a warning letter to the petitioner to lose weight.
So we cannot afford to be fat, Your Lordship.
So whether the action arbitrary or not, you have to examine that. Yes, okay. Enjoy your holidays.
Thank you.